Okay, where we left off on the last program, we're trying to establish that the United States has actually come under military control to the point of actually being definable as being under martial rule or qualified martial law. We saw from that the courts had warned us about the eventuality of this happening all the way back just after the Civil War, and in the mid-20s in the state of Michigan, Bishop versus Vandercook. But more importantly is the amplification of how those military powers have taken hold. And if you've been watching the news, it's even come to the point where Trump has signed an executive order that authorizes military tribunals over the civilian population. Now, that is the most cogent example of an exercise of martial law authority that you could have. Now, the Founding Fathers, when they wrote the Declaration of Independence, could have been a little more helpful to the successive generations that were supposed to uphold the obligations of American liberty. That in the Declaration of Independence, there is a list of grievances, and those various grievances are actually labelable in a more coherent understanding as being attributes of martial law. Okay, yeah, the Declaration of Independence had a laundry list of grievances that spoke of the abuses of the military under the authority of King George, and actually many of those things are still going on today. Here we go. All right, this is where we're going to start here. The Declaration of Independence speaks of numerous different grievable offenses that were committed by the military, the Redcoats, under King George. And there's a number of them there. He has refused his assent to laws the most wholesome and necessary to the public good. He has forbidden his governors to pass laws of immediate and pressing importance. He has refused to pass other laws for the accommodation of large districts of people unless those people would relinquish the right of representation in the legislature, a right inestimable to them and formidable to tyrants only, etc., etc., etc. Now, these are all attributes of martial law because they were all done by the established military government, the British military government established in the colonies. And if we see today what is going on with our government and the way we way we are seeing government operate today, these same kind of things are happening today, such as for suspending our own legislature and declaring themselves vested with power to legislate for us in all cases whatsoever. Now, is that what happens when the president or the governor signs an executive order? They take on the role of legislator, rendering the separation of powers meaningless. Again, from Declaration of Independence, he is effected to render the military independent of and superior to the civil power. Exactly, again, what's happening with the signing of executive orders. As I just heard recently, Trump signed an executive order imposing certain taxes. And I think that the tariff thing was done by executive order. Now, how can that even happen when those are aspects of exercise of governmental power that is supposed to be under the control of the legislature? So, what other signs of military authority? Well, we can look to the display of the Gold Ridge flag. When we look at Army Regulation 840-10, we find out that in Chapter 2 that it represents the power of the President acting in his role of Commander-in-Chief of the military. And in fact, if you look in the subcategories, you will see that the display of a gold fringe flag in a courtroom means it's a military courtroom. Now, the hypocrisy of Trump signing an order that now allows civilians to be tried in military tribunals, which is in and of itself basic treason, and referencing Ex parte Milligan again, 71 U.S. 2, United States Supreme Court case. We see that we already have military courts exercising authority over civilians. There's a gold fringe flag in every district court, circuit court, court of appeals, Supreme Court, both state and federal, all the federal courts up and down. Not to mention the ubiquitous display of the flag in schools, banks, all major corporations. These are aspects of military authority, and it's the international law has an aspect called the law of the flag. And with the law of the flag, which was derived from ancient heraldry, where knights and whatever monarchy or king you were fighting under, you displayed their particular colors. Well, this passed on to the nations through the law of the flags. And the law of the flag says that every aspect of a nation's exercise of governmental authority must be obvious by the display of some sort of symbol that shows the nature of the authority being exercised. Now, the reason that they've had to bring us into military courts is part of the whole martial rule, the underlying crypto martial rule that's going on. They couldn't do that in a constitutional format. And in order to bring legal action against somebody in a constitutional venue, you have to go against them in their legal name. Now, in these gold fringe flag courts, you're going to find that if you're ever brought into one of these courts or a suit is brought against you, it's not brought against you in your legal name, which is in all, not in all capital letters, but in upper and lower case. The capital letter of each of each of your names, first letter of each of your names is in capitals, and then the rest is in lowercase. That's your legal name. They represent your name in a corporate form, and that's your name displayed in all capital letters. Now, that is not a natural person. The representation of what is called a natural person, a living flesh and blood human being. That is a representation, a straw man representation, a legal fiction. Also can be called ens legis, a legal name. But it is considered to be a vessel because of the corrupt manipulation of jurisdiction, and as I explain this to you, you will see how it's a perfect example of the use of the Hegelian dialectic when they went from the original jurisdictions in the constitutional courts of the United States are threefold: common law, equity, and admiralty or maritime law. That's the international, the law of the sea, the jurisdiction of the law of the sea, admiralty law. And when those individual jurisdictions were kept separate and apart from each other, the rights of the American citizen, the individual rights of life, liberty, and property of the American citizen were most optimally protected. Now, how could that happen? Well, at the common law, that is the law that applies to everyone, and that's the law that does not need a whole listing of individual statutes or whatever. The common law was called the lex non scripta, meaning the unwritten law, and it is based in a very simple, understandable legal proposition that we are all entitled to live our lives as we please, as long as we do not violate the life, liberty, or property of another. And if one individual violates the life, liberty, or property of another, then a common law crime has been committed. Now, it can take various forms: trespass, murder, rape, and so on. And you'll see that all of those names have been relabeled in the statutory format. But in the common law jurisdiction, all that was needed was the ability to articulate a real crime against a real person. Corporations did not have standing in the common law. That's one of the failings of why they had to do what they ended up doing. And in common law, the punishments were of only two ways: either jail time or paying a fine. Then you move to equity. Equity deals with performance and having people do things or have them not do things. But when equity stood by itself, it was previously known as chancery. When equity jurisdiction stood by itself, it was the law of contract, the law of enforcement of contract. And the only way you could get somebody to do something or not do something was by the existence of a previously established contract in which the parties involved already agreed to the issues of performance contained in the contracts, in the four corners of the contract. And if there was something outside of the four corners of the contract that one party wanted the other to do, they had no standing, because the only issues that they could bring it up were the issues that were already agreed to by the parties. You couldn't bring in other things, or the court couldn't have somebody do something or not do something that was outside of the contract. But it required previous agreement. So, the issue of consent was perfected. It was consented to by the parties. The admiralty jurisdiction was nothing more than the issue of contract, but at an international level. It was an action in admiralty had to be between two nations, between one citizen of one nation and another nation, between vessels on the sea. And the use of the word vessel here is important because we're going to find out the trick that was used to turn us into vessels. And it also dealt with contracts that had consideration in gold, and that is another very important aspect of it because it really shows where that jurisdiction came from, and ultimately it goes back to Rome, and you'll see that much more follows the same route. So, but again, in Admiralty Maritime jurisdiction, again, you had to already have signed to a contract and have agreed to the conditions of performance, and the only claims that could be involved failure to comply with the demands of the contract. Now, what happened to make this go bad? Well, we went under martial law back in the back during the Civil War, and preceding the Civil War, common law, which is referred to in the Constitution just as law with a capital L, and equity were separate. Well, suddenly they decided that certain agents of influence decided to impress upon the legislature that they needed to do what was called the merging or uniting of law and equity in the and when you look at the Michigan constitutions going from 1835, 1850, 1908, and 1963, you will see that there was a progression of events that were designed to corrupt this merging or uniting of law and equity. The way it's referred to in the Michigan Constitution 1963 is that they abolished the distinctions between law and equity. But if you go to the constitutions of other states, it's the same kind of thing. The merging law and equity, uniting law and equity, eliminating the distinction between law and equity procedures. It's all the same thing. But what happens when you unite law and equity? Well, it actually turns the court into it turns the judge into a slave maker, because now after they're being united, the judge takes upon himself full discretion to tell the defendant that he has to do this or do that, even though there is no previous contract. That's where the idea of community service, and again, the use of the word service goes back to the ancient Latin servus, S-E-R-V-U-S, which means slave, and that's what we are also trying to show, that being under martial law, that in a very clever way, in the use of clever language, that we are in fact operating as slaves, although we don't have whips cracking on our back, or the other attributes that Hollywood tells us is slavery. In fact, the United States government and the government of the several states, operating through its corporate forms and banks, are a huge machine of wealth skimming that takes the wealth to support and uphold agents of foreign intrigue. I'll put it that way. So has this been ever addressed before, the merging of law and equity, and is there something amiss when that kind of thing happens? Well, it's already been addressed by the United States Supreme Court. And I'm quoting from Missouri versus Jenkins, 515 U.S. 70. It's a 1995 case, footnote 4. It says, the federal farmer particularly feared the combination of equity and law in the same federal courts. It is a very dangerous thing to vest in the same judge power to decide on the law and also general powers in equity. For if the law restrain him, he is only to step in his shoes of equity and give what judgment his reason or opinion may dictate. We have no precedents in this country as yet to regulate the divisions of equity as in Great Britain. Equity, therefore, in the Supreme Court for many years will be mere discretion. And there he quotes a federal farmer, which is one of the early magazines or publications, like the Federalist Papers, that dealt with the public discourse in the formulation of the government. Back to 1787. He quoting from the Federal Farmer, number 3, October 10th, 1787, in 2 Storing 244, which is a very, very old case. But continuing, in such a system, the anti-federalist writer concluded there would not be a spark of freedom to be found. So, how did that happen? Well, all we need to do is go to the Federal Rules of Civil Procedure and look at Rule 1. And they were very out in the open about it, very, very out in the open about it. And we'll put this up. When they created this new, what they call civil action, we refer to Rule 1 of the Federal Rules of Civil Procedure. It says these rules govern the procedure in the United States District Courts in all suits of a civil nature, whether cognizable as cases at law or in equity or in admiralty. Very important. With the exceptions stated in Rule 81. They shall be construed and administered to secure the just, speedy, and inexpensive determination of every action. So, going to the footnotes, the advisory committee notes, this happened in 1937 when they first adopted these rules. And the first thing they did was change the constitutional government, or the constitutional court, federal court, which was referred to as District Court of the United States, into what are now known as United States District Courts. That's the corporate form, the crypto-fascist form. And in the 1948 amendment to Rule 1, amendment effective October 28, 1949, substituted words United States District Courts for the words District Courts of the United States. Okay, footnote 3, these rules are drawn under the authority of the Act of June 19, 1934, rules dealing with rules and actions or laws, Supreme Court authorized to make them, and what is now 28 U.S.C. 2072, which is the statute that gave the United States Supreme Court the ability to make rules and procedures for the federal courts. Okay, in accordance with Section 723, the court has united the general rules prescribed for cases in equity with those in actions in law so as to secure one form of civil action and procedure for both. Sounds like they're trying to be very efficient, aren't they? They're trying to be, make it very, very easy and nice for us. But they're creating what they know is going to be an unconstitutional and treasonous mutation of constitutional jurisdictions. Okay, and it continues on with the particulars of how they mixed law and equity. So then you go down to the 1966 amendment of Rule 1 at the footnote. It says, this is a fundamental change necessary to effect unification of the civil and admiralty procedure. Just as the 1938 rules abolished the distinction between actions of law and rules in equity, this change would abolish the distinction between civil actions and suits in admiralty. Now, again, this is the Hegelian dialectic right in your face. They've got equity, thesis, law, antithesis, or switch them either way, and then mix in admiralty, because it really didn't change much. It just brought it into all in one form, into the international jurisdiction. And then it became one form of action. Looking at Rule 2, that became one form of action called the civil action. But doing that, it was a treasonous action. Going back to 1832, back when we had judges who thought in a constitutional manner, there was a case, second federal cases, 410, 1832, Baines versus James and Catherine. And it was a very important holding. It says, admiralty cannot be brought into a county. Now, admiralty has been brought into the county by virtue of the fact that they made these manipulations at the federal level, and we're going to show at the state level too, and these successive constitutions. In fact, they even will show that it was, in fact, a well-prepared in advance conspiracy, because they knew they were going to start legislating so that law and equity would be eventually merged. But they brought admiralty into the county by virtue of the fact that the Coast Guard had the job of finding the high point in every county. And if you go into every county in the state of Michigan, go to the highest point of the county, you're going to find a surveyor's mark indicating the highest point of the county. Now, admiralty is considered to have its jurisdiction going up to the highest watermark, what's called the high watermark. And the Coast Guard, through its regulations, moved the high watermark up to the highest point in the county. So, according to our courts, we're all actually underwater, completely underwater, and operating in admiralty, where law and equity has been merged into a dictatorial form of jurisdiction where the court has the ability to pretty much ignore any of your individual property, liberty, and life, rights to life, and essentially treat you as a slave in community service. Now, you can tell that there was conflict going in the time period, the decades just preceding the Civil War, as to the actual accomplishing of this stuff and the mixing of law and equity I'm referring to, the mixing of the jurisdictions. And say an example, going to case 1851, Bennett versus Butterworth, which is a United States Supreme Court case, 52 U.S. 669, 1851. It says, although the forms of proceedings and practice in the state courts have been adopted in the district court, yet the adoption of the state practice must not be understood as confounding the principles of law and equity, nor authorizing legal and equitable claims to be blended together in one suit. They're trying to say, oh, well, we see that you're trying to do this procedural merging or whatever, but you must remember that law and equity must remain separate. But that's been lost. And this was back in 1851. They were trying to warn us. And such as this 1868 case, Thompson versus Railroad Companies, 73 U.S. 134, 1868 case. If the remedy at law was adequate in the state courts, it is not to be changed from law to equity after the suit is transferred to the federal tribunal. Again, this is showing that the United States Supreme Court understood the importance of the separation of law and equity, and that you can't change horses in the middle of the stream, so to speak, as you move procedurally through your litigation. Now, even going to 1891, again, U.S. Supreme Court case, the U.S. Supreme Court saw that some of the states were starting to do some of this blending, and this is what they said. Demands of this kind do not lose their law side because in some state courts, by virtue of state legislation, equitable relief in aid of the demand at law may be sought in the same action. Such blending of remedies is not permissible in the courts of the United States. Well, that was 1891. The United States Supreme Court in 1934 obviously felt differently. Okay, so that's what happened at the federal court level, and this is the jurisdiction that the military authority is using. They're calling it the statutory jurisdiction, and it's composed of all these unconstitutionally legislated statutes that fail to conform with the constitutional formula for the enacting of laws. But again, this was also done at the state level, and we'll look at that real quick. Okay, I'm going to show you this. This is Article 4, Section 23 and 24 of the Michigan Constitution, 1963. Just going to show you this because it defines the procedural format as to how laws are to be enacted. And Article 23, the style of the law shall be the people of the state of Michigan enact. So whenever you have a law, you must say the people of the state of Michigan enact. And then 24, no law shall embrace more than one object which shall be expressed in its title. No bill shall be altered or amended on its passage through either house so as to change its original purpose as determined by its total content and not alone by its title. Now, they're all over the place with this. Example is the MCL, the Criminal Code, the Michigan Criminal Code, MCL 750.1 and following. There's a title saying the people of the state of Michigan enact, but then they proceed to show thousands of objects to this one law. So by its very nature, it's unconstitutional. And if you look very closely at the styling of the printing of the statutes and the Michigan compiled laws, you're going to find that they are not constitutional law at all. And if you look in the editorial commentary, in the preface, they will even admit to that it is the adding in of these things are done editorially. Now, I showed you Article 4, Section 23 and 24 of the Michigan Constitution of 1963. Now, that's the corporate form. And again, it formulates its legislation by having an enacting clause saying the people of the state of Michigan enact. Now, was it always that way? When you go to the first Constitution of 1835, the state of Michigan, you'll see that there were people there who understood the difference between constitutional and non-constitutional forms. And when they put the Constitution of 1835 together, the de jure, what's referred to as the de jure constitutional formulation of laws, was found in Article 1, Section 22 of the Michigan Constitution of 1835. And it says, the style of the laws of this state shall be it enacted by the Senate and House of Representatives of the state of Michigan. Now, that was the constitutional form, and if you look through when you go to the Constitution of 1850, you're looking at Article 4, Section 48. It says the style of the law shall be the people of the state of Michigan enact. They've already changed it, and they're 11 years before the Civil War. They're already moving towards the corporate form. And then the successive constitutions of 1908, 1963 all say people of the state of Michigan. So that's the corporate form doing its legislating. But what I want to try to establish also is the progression in the Michigan constitutions now. When you're looking at the Constitution of 1850, I'll have to look at the 1835 version, but I don't think it has any. It does not mention anything about mixing law and equity. Now you go to the Constitution of 1850 at Article 6, Section 5, they're already doing their manipulating. It says the Supreme Court shall by general rules establish, modify, and amend the practice in such court and in the circuit courts and simplify the same. The legislature shall, as far as practicable, abolish distinctions between law and equity proceedings. The office of master in chancery is prohibited. Now, it's interesting that they put a mandate for the legislature in the particular article that deals with the judiciary. Here they're telling the legislature to start legislating in a manner that abolishes the distinctions between law and equity, but it's in the section of the Constitution dealing with the judiciary and courts. And in order to do that, they also it indicates the office of master in chancery is prohibited. Chancery is just the other name for equity, but the word chancery actually shows the connection, the long-term historical connection from whence our judicial system came from. And chancery goes all the way back to England, to the Temple Bar, and what was called the chancel. And chancery jurisdiction was the jurisdiction of the chancel, and that was essentially the equity jurisdiction, the jurisdiction of contract. But the chancel was acted as agent of the Vatican and the Pope. So you were entering into contracts or having your contracts enforced by the ecclesiastical operations of the Vatican. But that's where we get our equity from, and they changed it from chancery to equity, probably to try to sever the understanding of the historical connection as to how equity goes all the way back to the Temple Bar and the chancel. Okay. That was the Constitution of 1850. Looking again the same, Article 6, Section 5, in the Constitution of 1908, again, pretty much the exact same language as the 1850 Constitution. And then going to the Constitution of 1963, again, it doesn't inform the legislature that they need to start legislating anymore. In the Constitution of 1963, it just says that the practices are abolished. So the legislature is already full steam ahead in the abolishing of law and equity. Okay. That deals pretty much with issues of law and equity, and in the next program we will start getting into issues considering the use of the statutory codes in the military courts, and if in fact they are constitutional or not. Okay, have a good day.